opinion of the President's decision in accordance with the Constitution upon the advice of the Council of State as unconstitutional?
Thank you very much for the opportunity. I think what we meant by that is that, there were allegations or statements that before the sitting president, as we have it now, became president on his campaign trail, he made certain comments that when he won when he became president, he would remove the Chief Justice. I think I've heard something like that. Then the other side to counter that, okay, now that he started a process, or they also come in the future, we'll do same. Those are the comments that we are referring to, that they are prejudicial, and we don't want to hear them from both sides. Probably before we didn't say it this way. That is what we meant.
But that's what I'm saying, that in this same statement that you raised this concern, you are also essentially making comments and expressing your opinion about the President's decision, which is consistent with the Constitution, as you have acknowledged that he's done nothing wrong. So why are you condemning something that you are condoning in this same statement?
What we mean, I believe you are referring to where we said the President's suspension of the Chief Justice is unconstitutional.
It's unconstitutional, yes.
I believe that's what you are referring to.
Exactly so.
Let's put it in a context. The reason we put it that way is that yes, the President has every right to exercise his discretion to suspend the Chief Justice per the Constitution. But Article 296 also tells us how discretion should be exercised, to the extent that we sitting members who were at our conference were of the view that in this particular instance, relative to the suspension of the Chief Justice, the President ought to have caused a publication of regulations in the nature of constitutional instrument or statutory instrument before going ahead to exercise that discretion. So it's not as if we say that he has no right to trigger the process.
I see. But is it in your place as a Ghana Bar Association to declare the President's act in accordance with the Constitution as unconstitutional?
I think that we are not doing this in our capacity as a judicial authority. Many times you hear people say, oh, this is unlawful, this is unconstitutional. It doesn't mean that those people are they conjure themselves into court. Maybe the cost is coming from us as an association. That is why you haven't an understanding. There is no way that we can ever equate ourselves with a court of competent jurisdiction. We are just describing what has happened that is unconstitutional. That is our thinking. So should we even decide to pursue it further? Maybe if I go into court, I said maybe that may be the grounds on which we'll be going. That does not mean that we have already decided to go.
But the others who also hold the view that yes, this act is constitutional. What would be the GBA's position on that?
Can you take that again?
I'm saying that as you describe that decision as unconstitutional, others also hold a strong view that what the President has done is constitutional. What's the GBA's position on that?
That is their view. If you put two lawyers together, I can tell you on one issue you have the same position. So that is the beauty of it.
So let me establish this.
At a meeting,
right?
At that meeting, we hold the view that by not publishing the regulations before suspending the Chief Justice, that conduct or exercise of that discretion was unconstitutional. So if there are others who hold a contrary view that, look, irrespective of that, it's constitutional, we will not fault them because that's their position.
But can you point to me?
Even at the GBA meeting, different views were expressed, except that just like it happens at any other meeting, whatever majority agree on, that is what carries the day.
But point to me exactly what the President has done that you describe as unconstitutional. Exactly what has he done?
I think that is what I've just said, that the failure to have caused regulations to be published relative to his exercising his discretion in suspending the Chief Justice. But that is why we say so.
But you agree that the regulations you talk about, in the absence of the regulations that you are expecting to be published, the President can only work with what is existing now, is it not, in the Constitution, correct?
Yes, the President has, you listen to me this way, the President has the right to suspend the Chief Justice. So he has that discretion to exercise. But we are saying that in exercising that discretion, he should have recourse to Article 296, which says that once he's not a judge or a judicial officer, he ought to have caused a regulation to be published in the nature of a CI or statutory instrument. That's what we're saying. So we are not saying that he cannot go ahead, but in go ahead, we expected him to have affected his mind to the provisions of Article 296, which required him to publish a regulation in the nature of a constitutional instrument or statutory instrument before exercising his power to...
So are you saying that the President should have disregarded what the provision of the Constitution is?
The President should have
disregarded what the provisions of the Constitution is, because as you acknowledge that yes, he acted. I'm coming to the point. You acknowledge that he acted based on the dictates of 14610A, but then again, not recourse to 296. But specifically,
so which means that he had not fully completed the process before he started. Well, it should have concluded by having the CI published before. So we are not saying that he cannot exercise that discretion, but we're saying that in doing that, he ought to have affected his mind to 296, which required him to publish regulations.
But the dictates of 146 is pretty clear, is it not?
The dictates of what?
146 is pretty clear on exactly what the President has to do in this particular instance.
He may exercise discretion. Is that not?
Absolutely. So why do you say the process? You say he started that. I'm coming to a point. You say he started the process, but he should have before. Is that mandatory in law?
No. Excuse me. Hello?
Yes, I can hear you.
Yeah, the question again.
Yes, I was saying that you were saying that he started the process well, but then again, at the point of suspension, he should have averted his mind to 296. And I'm saying that is that consistent with the provisions of 146 specifically?
Why not? Because 146 says he may suspend the Chief Justice. The name makes it discretionary. So to the members sitting at that meeting on Saturday, they think that, or they held the view that that situates in the context of 296 relative to exercise of discretion. So he ought to have published or caused to be published regulations relative to the exercise of the discretion he is supposed to be exercised, or he has permission to, or he has the right to exercise under 146. That is the context in which the meeting was done.
I see.
At that meeting, various people held various views, just that at the end of the day, this is what majority thought should be the meaning of.
Prior to this conference that you GBA had on Saturday, 2 days before that, you had issued a statement describing this entire process is sub judice, and so you were hoping and expecting that the dictates of 146 will be followed as stipulated, and that you're going to watch closely. Then 2 days later, you go for a conference, and then you issue a statement describing this process that you acknowledge in the first statement as unconstitutional. I mean, how do you expect the generality of the public, mortal and mere men like us, to then take the two positions of the GBA?
Yes, I will explain that. The GBA has a hierarchy when it comes to decision making. The first statement that came out within the week was on the instructions of the Council and the General Council of the Bar and the National Executive Committee. The GBA is a high decision-making body, is the conference of the Bar. So either it's media conference or annual general conference. That's the highest decision-making body. So having issued that statement and having gone for conference, media conference, and members of media conferences that look, irrespective of the fact that he issued this statement already, this is the position we want to take. I think that nobody will say that we should forget about that, because that is the highest decision-making body. So if at that forum they agree that irrespective of what we done earlier, this is the new stance we want to take, I don't think they've done anything wrong.